In today's video, I want us to think about two categories of documents. First category are those documents that have been issued by an official body. Official body may be a government, it may be a university, or any other institution that is recognized in some official capacity. The second category of documents that I want to reflect on are those documents that purport to be a statement by some individual, in particular where the individual made the statement and wants this statement to be attributed to him or her. Returning to our first category of documents, those that have been issued by some official body, in those cases, the certificate is typically issued, or document is issued in the form of some certificate, such as a birth certificate, a degree certificate, or any other certificate that certifies some qualification. And those documents are required for various processes. As one example, when one applies for a job, one may be required to submit proof of the qualifications that one obtained. And while it's possible to submit the original qualification certificate, that's not a good idea. That certificate may be required to submit other job applications. That certificate may also get lost in the process of applying for a job. And generally, they are rather hard to replace if lost. So what happens in practice is that one makes a copy of the original document and then somehow gets the document to be certified, specifically gets the copy to be certified as a true copy of the original. In our second example, or second class of documents, those that represent declarations made by people, often individuals are entrusted with responsibility and also the power to take down a statement, and that statement will then be deemed to be a true representation of what the person said. And this is where these two topics come together, because the same people who are able to take down a statement and certify it as something that has indeed been made by the individual concerned, those same people are often in the position to certify a copy of a document as an exact copy of the original. Before we proceed, there are a couple of caveats that we need to consider. Number one, the topics that I will be talking about today are not in my field of expertise. Hence, I can tell you about what I've read about it, but do not consider this to be legal advice or authoritative in any manner. However, I do think that many of the aspects that we will be talking about currently exist in the physical world, in a paper-based world. So most of the documents that we will be referring to are physical paper-based documents, and there is scope to move that to the digital sphere if necessary. In fact, in a couple of jurisdictions, it has already moved to the digital sphere, so we don't even have to speculate about everything. We can find some specific examples. The question whether we need to move these processes to a digital sphere is something that needs some reflection. But we should also be cautious, because these processes are governed by legal processes, governed by laws. And if we come up with some brilliant solution of how to do this in the digital world, it is very unlikely that the legal system will just accept this digital approach that we are proposing. One of the other caveats is the fact that terminology differs extensively from one jurisdiction to another jurisdiction. Now, being from South Africa, I will generally use the South African terminology, but I will try to refer to international terminology where appropriate. Talking about jurisdiction, the processes that are involved may also differ from one jurisdiction to another jurisdiction, but generally those processes are not as significant as the terminology, because we are talking about processes that are in principle rather simple. Given that the topics that we will discuss are generally paper-based processes, means that there is not too much that we can say about authentication of digital documents or examination of digital documents, and therefore the video will be rather short. It's intended as a taster of sorts, something that gives us indication of documents that may be questioned in future, that may exist in a digital form. The general theme of the current series of videos is the examination of questioned digital documents. We noted that the two categories of documents that we are particularly interested in at the moment are categories that have not really moved to the digital sphere, at least not extensively, and we have to think a little bit broader. But the principles remain the same whether we are talking about the digital world or the physical world. What we want to avoid in the examination of these documents in general is the requirement to go back to the source. What I mean by that is, if we have a statement that was made by an individual, then we do not want to be forced to go back to that individual and then ask the individual whether this is indeed a true reflection of what he or she said. In fact, that individual may even have changed his or her mind in the meantime, which introduces other problems. Similarly, when we have a copy of a document and the document has been certified in some manner to be an exact copy, we do not want to have to go back to the original in order to verify that the copy is indeed an exact copy. So what we need in both of these cases is someone who can be trusted, someone who can indicate in some way that this copy is indeed an authentic copy or an exact copy of the original, someone who can indicate that the person really made this declaration, and this somebody should be trusted. This takes us to some ancient history, back in Roman times, even early Roman times. When people wanted something to be written down, they generally had to find a scribe to write down whatever they were saying. But since most people were not able to read, they couldn't even read to verify what the scribe said, whether the scribe recorded their words correctly. Some scribes developed a reputation that they were particularly reliable. So if you wanted an exact representation, an exact rendering of what you said to be written down, then you would find those scribes. And also, if something was written down by those scribes, then you knew that whatever was written down could be trusted in terms of being an exact representation of whoever dictated the contents wanted to have written down. That developed into a profession in Roman times, and the words in the Roman context typically refer to some aspect that relates to a notary, terms that involve words like notaries and so on. But I'm not going to try and explore the exact role of those Roman notaries, if you want to call them that, or even the terminology that was used, and also the history of how it progressed. The point is that that function, this trusted person, has continued throughout the ages. It was carried by Roman law into much of Europe, later on replaced by the civil law systems, but that function remained. In the United Kingdom, the notion only developed much later, developed very differently, but it boils down to the same effect. We will see some of these differences when we talk about the international use of these professionals a little bit later on. In South Africa, a person who is qualified, who is authorized to take down a declaration and indicate that the person made that declaration is known as a commissioner of oaths. In South Africa, the appointment of and operation of commissioners of oaths are regulated by the 1963 Justices of the Peace and Commissioners of Oath Act as amended. The Act specifies who may be appointed as a Commissioner of Oath and how the process works in general. More specifically, the Minister may appoint anybody as a Commissioner of Oaths, and occasionally regulations are published in the Government Gazette that specify who qualify to be Commissioners of Oath. The list includes people who are in certain ranks in civil service. It includes various professionals such as lawyers and accountants, and it also states that anyone who wishes to be appointed as a Commissioner of Oaths may apply to do so. In all of these cases, the appointments are for a limited period of time and may be withdrawn by the Minister at any given moment. One of the interesting categories for viewers of this video may be who at universities are deemed to be Commissioners of Oaths, and the list is displayed on your screen right now. This is the list according to the latest list published in the Government Gazette. As the name indicates, the primary function of a Commissioner of Oaths is to administer an oath or an affirmation. So the process generally works as follows. If someone wants to make some sort of a sworn statement or an affirmed statement, they would write it up as a declaration. They would then take this document to a Commissioner of Oaths, and this is one of the physical parts. This person has to appear in front of the Commissioner of Oaths. So it's a physical appearance which brings in some problems if you want to consider a digital equivalent process. So the person who wants to affirm or attest to this declaration is known as the appearer or the deponent. When the appearer or deponent appears in front of the Commissioner of Oaths, the Commissioner of Oaths will ask three simple questions. Question number one is whether the appearer, the deponent, is familiar with the contents of the declaration. Obviously, if the person is not familiar with the contents of the declaration, then the process cannot proceed because the person cannot attest to the veracity of the contents of that declaration. Question number two is whether the appearer has any objection against taking the oath. If the person does have an objection, then the oath will not be administered, but an affirmation will be administered. Question number three is whether the person finds the oath binding on his or her conscience. And if the person says yes, then administration of the oath can proceed, else we also revert to the process of affirmation. But whether it's an oath or an affirmation doesn't matter in the end because both carry the same weight. Both have exactly the same value. If the oath is to be administered, then the deponent is asked to say the following words. I swear that the contents of this declaration are true, so help me God. If an affirmation is administered, then the words that the person has to utter are, I truly affirm that the contents of this declaration are true. The person is then also expected to sign the declaration in the presence of the Commissioner of Oaths. So again, there is a problem if we want to implement a digital alternative to this system. At this stage, the Commissioner of Oaths will stamp the document and complete the details of the date and place where this oath or affirmation was administered, and also sign the document. If the Commissioner of Oaths doesn't have a stamp, then the Commissioner of Oaths can also write something to the effect that says that the oath was administered properly, and provide the details about where and when, and sign it. To make that part digital is not hard at all. The second function that I mentioned, that of certifying copies as being true copies of original documents, is a function that I have always assumed to be a function that is administered by Commissioners of Oath. However, it is interesting that the Act does not mention certification of copies at all, and there are some conflicting information on the web about exactly who is allowed to certify a copy of a document. However, I will proceed in this video under the assumption that it is a Commissioner of Oaths who is authorized to certify a document as being a copy of the original. In that case, the process, from experience now, not from the Act, would be that the person who will certify the copy will look at the original and will look at the copy, compare the two. It is usually a cursory comparison, so they won't read it, they don't go into the details. And if the copy does seem to be an exact copy of the original, then the person will also stamp it with a rubber stamp, provide the details about exactly who is certifying this copy, where and when this is happening, and the copy is now deemed to be certified. The alternative also exists for, in this case, for someone who doesn't possess the appropriate stamp, to write in words that this is an authentic copy, and then provide the outstanding details, the remaining details about the person's ability to act as a Commissioner of Oaths, and signing it and dating it, and so on. One of the challenges that is not new at all is the challenge that many of our documents are no longer issued in paper format. Your utility bill from your local municipality, your bank statement, those used to be paper documents, and the certification process was a very simple process of providing the original and the copy. However, if you receive your bank statement via email and you need a certified copy of it, how do you proceed? It seems that there are many people who are Commissioners of Oath or in an equivalent position who are willing to look at the original on the, let's say, your cell phone, look at the printout that you've made on paper, and then certify that paper copy as a true copy of the original. The challenge, of course, is how do you know that what you are looking at on the screen is indeed the original and not something that has been created using a paint program or some graphic software. Many notes exist on the internet that advises people how to act in this case, and most of what I've seen do suggest that people should indeed certify these printouts as I've just described. But it does provide us with a problem, because it is much, much harder for a person to judge an electronic, a digital document that is displayed. In other words, something that is humanly readable. and say that you've seen the original and you've seen the copy, and you can therefore certify it. If we are talking about real proper digital documents that may be in binary, then obviously you can't even do a visual inspection of the document. And for example, to look at a public key that happens to be a number of digits and say that this whatever you are seeing is an exact copy of that public key, that becomes much harder, and we're not going to look at that specific process right now. The fact is that so-called e-notary services do exist, and these e-notary services basically act as we would see a Commissioner of Oaths act when they were to sign a document as being a true copy of an original. The challenge, as you can see on this Wikipedia page that is being displayed now, is that the person still has to appear in front of the, in this case, e-notary, and the e-notary can then just sign the document digitally. So it adds very little value to the entire process. Given current circumstances where many of us were in lockdown and you couldn't go to a Commissioner of Oaths and you needed a certified copy, then a digital solution would have been preferable if you did not have to appear in front of the Commissioner of Oaths or whoever else is qualified to certify this copy. So there's much room for improvement here, but we should also be careful, because if you don't have to appear, it is harder to verify your identity, and some of the other aspects are harder to verify. It is unclear that the Commissioner of Oaths can verify your identity and say that this is indeed your signature that you've made in the presence of the Commissioner of Oaths. So there's a lot of room to think about, but how to do this properly, especially if we do not have support, legal support for proper digital certificates in the country, then it's basically something that we cannot even start with before going anywhere. We are stuck. The benefits of having a declaration that has been sworn to or that has been affirmed is that it carries much more weight than a document that has merely been, let's say, signed by you. From this point on, I'm going to talk about an oath in general, and I would use that to include the notion of an affirmation, just so that I don't have to repeat the word affirmation in every case. So once you've sworn to a declaration under oath, then that, as I've said, is a document that carries much more weight than the document that you've merely signed. Amongst others, a court may accept a document that has been sworn to. Typically, in this case, it will be known as a sworn affidavit or an affidavit that has been deposed to, is a document that a court will generally accept as evidence. It obviously depends on the jurisdiction and the specific nature of the case. Not everything can be handled because, amongst others, people who are accused of a crime are very often allowed to face their accuser, and to just move that to a paper basis cannot be done. But in terms of expert testimony, where the expert just provides an opinion and is not the accuser, then in a number of jurisdictions that sworn affidavit will suffice. The expert does not necessarily need to appear in court, especially if the experts on behalf of both parties tend to agree in most respects, and there is very little to question them about. However, let's repeat this one final time, this does depend on the jurisdiction. The reason why this sworn affidavit or this sworn declaration carries more weight partly comes from the fact that a false declaration, a declaration that has been sworn to but that happens to be false, is generally a crime, and whoever is sworn to it, at least if it's been done knowingly, is subject to punishment. And the punishment for perjury is what applies in this case. So if someone knows that swearing to a lie has certain potential negative consequences that may be quite serious, then that person is arguably less likely to lie under oath, literally, and hence the document carries more weight. Now, we should be careful here because the Commissioner of Oaths, as I've described it, is not involved with the contents of the document at all. The Commissioner of Oaths merely asks the deponent, number one, whether the deponent is familiar with it and so on, but eventually, do you swear that this is the truth, or do you affirm that this is the truth? And once this has happened, then the person has sworn to it or has affirmed it, and hence it carries the weight that is associated with a sworn statement. What the Commissioner of Oaths can really certify is that the appropriate process has been followed, that the oath or the affirmation has been administered properly, and the Commissioner of Oaths does not have any knowledge of the content of what has been sworn to, but merely states that the person to whom this oath has been administered was willing to swear to its truthfulness. Let us now go on a quick tour through the world, because at the beginning of this video I already mentioned that the terminology is not standardized through all jurisdictions, and we need to look at these notions on a larger scale to understand some of what is to follow in this video. Let's start our tour in the United States. In the United States, a notary public is basically the equivalent of a Commissioner of Oaths in South Africa. A notary public is a person who has no specific training, so it is a lay person in essence. Yes, some lawyers may become notary publics and so on, so they may have legal knowledge, but it's not a requirement. It's the same for a Commissioner of Oaths in South Africa. A lawyer may act as a Commissioner of Oaths and have legal knowledge, but in general one cannot assume that a Commissioner of Oaths has any legal schooling. So in general, notaries public in the United States cannot give any legal advice. They cannot deal really with the contents of a document, but they can merely take or administer an oath or an affirmation or certify a document as an exact copy. It's interesting to note that there are exceptions, notably the state of Louisiana in the United States, which was a French colony and got its state legal system from France, which is not a common law system, and notaries public there have a very different function. The next stop on this tour is basically all the countries that use a common law system. Those in particular on our little tour now are typically the former British colonies that inherited the common law system from Britain. Remember that in the common law system there is no prescribed code as such that codifies the law, and in particular it tends to be an adversarial process where two parties use analogies and then they fight with one another about legal matters, and precedent is very important in these cases. All of that doesn't really matter. The point is more that the notion of a notary was also inherited from the English, and the English, as we said previously, were not as much influenced by the Roman notion of a notary. So in these common law countries, you tend to have notaries who are primarily working with documents that are intended for international use. They tend to be people who have been trained in the law, so legal professionals, but they are not the ones who would normally certify a document as an exact copy or take sworn statements. It would be in exceptional circumstances, in international cases, where they would apply that. In many of those countries, you will find that there is a Commissioner of Oaths who fulfill the same function as the Commissioner of Oaths in South Africa. Moving on to our next stop on this little tour are the civil law countries. In this example, mostly Europe. Remember that in Europe, when Napoleon conquered Europe, he introduced the Napoleonic Code, but those countries before that were exposed to the Roman legal system, and they kept the notion of a notary, and these are not notary publics. You may have heard previously that I referred to a notary public in the American context, also notary public in most of the common law countries. But these notaries in the civil law countries are trained legal professionals. They are trained specifically in private law, in other words, the law that governs the relationship between individuals, also between an individual and a company or between two companies. That is in contrast to criminal law, where you have laws that are prescribed by the state and applies to the citizens, whether they are real people or corporations, companies, and so on. So in the civil law countries, it is in these agreements between various parties, in particular if we think about contracts between them. And it's in this context where a notary in a civil law jurisdiction will be an important party. So a notary in this context will be one that can draw up contracts, as one example, between two parties. So the notary is intimately familiar with the contents of this agreement. And the notary can also ensure, double check, that both parties or all parties to the contract understand it, agree to it, and when they sign it, that they have a common understanding. And what adds to such a notarized agreement is the fact that the notary has the witnessing power of the state. So once this contract has been signed with the aid of a notary, it is basically the state who says, this is indeed what the parties agreed to. And now for parties to begin to dispute matters becomes much harder because the notary was involved. The state witnessed the signing of the agreement between these two parties. So it is a very, very different role than the notary public in the United States or even the notary public in common law jurisdictions. South Africa is one of a few countries that have been influenced by both legal systems. As you may recall from one of our earlier videos, South Africa inherited much of the Dutch Roman legal system that included a lot of Roman law and the notion of a notary as it was seen in ancient Rome, that of a trusted scribe was inherited. And then under English rule, the notion of a typical notary was also introduced. The typical notary public was also introduced. So in South Africa, the notary is much, much closer to a civil law jurisdiction. In fact, in South Africa, to become a notary, one has to become a lawyer first of all, and then do some additional studying, write an additional examination, and then once one has passed that examination, one can practice as a notary. So by definition, a notary is already a lawyer, can give legal advice, can draw up contracts, and then can also offer the witnessing power of the state. So an interesting combination that we see in South Africa. Also in, I assume, most jurisdictions, but specifically in South Africa, a number of agreements can only be drawn up by a notary. One of the examples is an antenuptial contract. An antenuptial contract cannot be drawn up by a normal lawyer. It has to be a notary who will notarize it, and by notarizing it will attest to the facts that the parties reached an agreement about this, and in terms of the procedure will also emboss the document, his or her embossed seal. So it is, in a certain sense, sealed as an agreement that has been reached. One of the other examples where a notary is involved is in the transfer of fixed property. To transfer fixed property, someone has to be a notary who will draw up the necessary documents for registration at the deeds office. But the person also needs to be qualified as a conveyancer. So again, it's a lawyer who has an additional qualification to act as a conveyancer. And this conveyancer can then appear at the deeds office and say that person A is transferring his or her fixed property to person B. And that will then be recorded in the deeds office. It will be recorded as a copy of the agreement that has been reached. Being in the deeds office means it is open for public inspection. So people, for example, who want to look at providing one with credit can go to the deeds office and look at the fixed property that one has, and can there also see the type of agreement one has if one is married, whether it's in community of property or outside a community of property. In other words, does one own that property, that fixed property, in your own name, or do you own it as part of the shared estate of a married couple, or whatever the case may be. Also, if any bonds are registered on that property, for example, if you had to borrow money to pay for this transaction, then the bank will typically have a bond registered at the deeds office, and also that is open, that is available for public inspection. To make this more concrete, here is the deed that gives me ownership of my house where I am currently recording this video. It has been drawn up by a notary. So this is a deed of transfer, and it indicates that the property has been transferred to me. And if one goes to the last page, and I will have to provide a picture of this because it won't be obvious on this video, but there is the embossed seal that has been attached or that has been affixed to this document. So this document, in principle, gives me the right of ownership, the right to live on this property, but also the right to sell it. It's not a bearer document, so if anyone were to steal this document, they can't go and sell my house. But I guess it would be simpler for them to do so. So it is a document that I have to store securely somewhere. Such a deed of transfer will be recorded in the deeds office, which in South Africa, interestingly enough, stems from an extremely old law that I'll put on the screen here. And when you look at the start of it, you can see that it is when South Africa was still firmly under British rule, and that the act was drawn up in the name of the king. And townships way back in 1937 had a very different meaning from what they have currently. So rather interesting piece of legislation to read through. doesn't say much. It's a very short law. But the idea was to unify the legislation of the former independent republics and British colonies and the union that was established in 1910 to form South Africa. As I mentioned a moment or two ago, the Deeds Office makes copies of these deed records, and they return the original to the owner, or if there's a bond registered on the property, if one had to get a loan to buy the property, then the bank will retain this deed until you have repaid the loan, because the bank may sell your house if you do not repay the loan, and they need this document to be able to sell your house. According to the Deeds Office website, what they do nowadays is to microfilm the document before they return the original. They may obviously also change the technology that they use depending on what happens to be current practice at any given time. A notary will also make a copy of documents that they have notarized, and they will enter it in their so-called protocol or archives. So that also provides you with a second copy of the document that the notary can say, this is what I've notarized, this is what the agreement was. So if there are any questions about a document, then it is possible that a copy may exist in the Deeds Office, if it is the type of document that goes to a Deeds Office. And if a notary was involved, then a copy will also be available in the notary's protocol, in the notary's archives. And authentication of such a document becomes much easier because these are, as we said earlier, deemed to be trusted people in a professional capacity, reliable people, and they can testify to the authenticity of their copies, and hence it becomes very easy to find out whether a document about which any questions exist is indeed correct or not. This provides us with an opportunity to think a little bit broader, because why can't we have repositories for digital documents, and then you can deposit a document in such a repository like a Deeds Office or like a notary's archive, and if there are any questions about the document at a later stage, then one can call on these parties to produce the copy that they know to be a true copy. The challenge, of course, is that these need to be trusted people who offer these services, and typically it will mean that they have to be notaries or act in some other recognized capacity for this to work properly. One of the benefits that I can see with such a repository is that the documents can be signed using whatever technology is applicable at the time the document is deposited. So if a certain key length is required to keep it secure, then it can be signed using that a key consisting of that key length. If at some later stage it is determined that such a key length is no longer quite appropriate, the document can be re-signed, because what this repository does is merely to say that the copies that we have are authentic copies, and they can keep on signing them whenever technology changes and whenever it is a requirement to update the signatures based on technological progress. In fact, one can ask the question whether signing is indeed the best option here, because what you really need is a system where only the notary or whoever is designated to access that particular repository is able to make changes to it. So once a document has been deposited in it, then it will remain there as a deposited document forever, and the party who deposited it does not have to deposit it again. The person's presence is not required. It's not necessary for the person to sign it again. The perfect access control mechanism would be sufficient. But in the world of computer security, we know that perfect systems do not exist. Even with cryptography, the system or the algorithm can be broken. One possible solution is for the service to sign the documents using different algorithms and different keys. So if one is broken, then the others are still standing, and they all indicate exactly the same thing, that the document has been deposited in that specific format with that specific content on a given date, and it merely certifies the correctness of the document. So this is something to think about. How do you provide such a digital service? Do we need to use signatures and re-sign things every once in a while? Can we employ some form of access control scheme? What, technologically speaking, is the best approach? As noted earlier, we are not lawyers, so we cannot say what would work on a legal level. But as computer scientists, we can speak to the trust that one can place in technology, and then one can dream about the best technological solution for the problem that we've described. How do you put something in a repository where it will remain forever? Now, clearly, this raises another question. If such a repository is created, then it has to be maintained. And who will be responsible for maintaining it? If a certain company, for example, creates such a repository and they go out of business, does it mean that everything in their repository is now lost, is now no longer certified or notarized or whatever one wants to call it? How do you ensure longevity of this particular archive? It's another challenge to think about. At this stage of the video, I included a discussion of authenticated use of documents on an international level. This requires a document to be legalized, a fairly lengthy, complicated process, or by means of a much simplified process for countries which are members of the so-called Hague Convention. In this latter case, an apostille is attached to a document to show that it is valid, and an apostille attached by one country who is a member of the convention will enable the document to be used in another country that is a member of the convention. However, this discussion led to a rather long video, and it didn't really contribute to the message that I wanted to convey. Hence, I decided to cut that part out. However, in the apostille case, there is the interesting fact that the apostille can be issued on a digital basis. If countries have a system in place where they can sign documents digitally, then they can sign this apostille, this certification that the document is accepted in its home country. Then they can sign that digitally. However, it also requires the receiving country to be able to work with digital signatures, and hence the e-app or e-apostille process is only applicable if both countries can handle such digital signatures. One of the interesting aspects and one of the reasons why I wanted to discuss the e-apostille is the fact that it uses PKI signatures. The problems that we associated with signatures in a previous video do not necessarily apply when you have government entities beginning to sign documents. It's also interesting to note that for this e-apostille process, they decided to use Adobe products, and the reason why they decided to use Adobe products is because the Adobe products that they are using do not assume that any certificate is trusted. That is unlike what we've seen in our discussion of trust in operating systems and browsers in general. And in doing this, it means that one country will not necessarily accept another country's signature because there is some unknown party that signed a certificate somewhere in the middle. Every certificate has to be imported manually. I suggest you look at that e-apostille process at some point if you have time. But the only importance it has for the remainder of this video is the fact that I do refer to it again at some later point in the video. In summary, we have looked at documents that originate from an official institution like a country or a university, and we have looked in particular how certified copies of those documents can be made. And we've even seen that copies can be certified of digital documents, paper copies, and there is even an e-notary system that is used in some locations that can be used to sign a document. We've also looked at documents that contain utterances, declarations, statements by people that have been sworn to or attested as a solemn affirmation, and that carry in principle evidentiary weight and also the potential penalty of perjury if they are incorrect. All of these systems are systems that can be applied to digital documents, and once they are applied to digital documents, it makes it very, very simple to authenticate a digital document. However, many of these also involve processes like advice from lawyers or advice from qualified notaries that are much harder to implement in a digital system, and therefore the entire process cannot be automated or is unlikely to be automated. But we don't need the entire system to be automated. For our purposes, we are really interested in authenticating documents. So if we can get documents signed in an appropriate manner digitally or stored in a secure digital repository, then it makes it very, very simple to answer questions about any such document that is contested. So there are definitely opportunities, but the legal systems need to adapt where they have not yet adapted. And frankly, the technology is not quite in place there yet. So rather than blaming the legal system, it behooves us to begin to think about how best to implement such systems so that they indeed speak to the veracity of, at the very least, the process that has been followed to administer an oath or a solemn affirmation or to certify a document. Another question that arises from this is, in the case of digital documents, there is no real need to certify a copy because one can split the original without destroying the original, and the original can be provided as and whenever required to as many parties as required. So the whole process of certification seems to become unnecessary. However, we do need something, some mechanism that perhaps doesn't properly exist in the real world at the moment to say that this digital document is indeed authentic. And once it has been marked as authentic, then the original can be used as many times and whenever possible. And even on the international level, using something like the e-apostille system can be used as an extension of such a system, where the document is certified upon issuance rather than certified on the basis of its likeness to an original document. That clearly requires some thinking because it increases the number of parties who are involved in such a process. And as the number of parties increases, we run into more and more of the problems that we saw in the video that dealt with digital signatures. As the name indicates, the primary function of a commissioner of oath